5 seconds to go. Start. It will be relevant to refer to the following observations of the Privy Council in the said case. The second question, which involves the construction of Section 27 of the Indian Evidence Act, will now be considered. That section and the two preceding sections with which it must be read are in these terms. Section 27, which is not artistically worded, provides an exception to the prohibition imposed by the preceding section and enables certain statements made by a person in police custody to be proved. The condition necessary to bring the section into operation is that the discovery of a fact in consequence of information received from a person accused of any offence in the custody of a police officer must be deposed to and thereupon so much of the information as relates distinctly to the fact thereby discovered may be proved. The section seems to be based on the view that if a fact is actually discovered in consequence of information given, some guarantee is afforded thereby that the information was true and accordingly can be safely allowed to be given in evidence, but clearly the extent of the information admissible must depend on the exact nature of the fact discovered to which such information is required to relate. Normally, the section is brought into operation when a person in police custody produces from some place of concealment some object, such as a dead body, a weapon, or ornaments said to be connected with the crime of which the informant is accused. He has argued that in such a case, the fact discovered is the physical object produced, and that any information which relates distinctly to that object can be proved. On this view, information given by a person that the body produced is that of a person murdered by him, that the weapon produced is the one used by him in the commission of a murder, or that the ornaments produced were stolen in a dacoity would all be admissible. If this be the effect of Section 27, little substance would remain in the ban imposed by the two preceding sections on confessions made to the police or by persons in police custody. That ban was presumably inspired by the fear of the legislature that a person under police influence might be induced to confess by the exercise of undue pressure. But if all that is required to lift the ban be the inclusion in the confession of information relating to an object subsequently produced, it seems reasonable to suppose that the persuasive powers of the police will prove equal to the occasion and that in practice the ban will lose its effect. On normal principles of construction, their lordships think that the proviso to Section 26 added by Section 27 should not be held to nullify the substance of the section. In their lordships' view, it is fallacious to treat the fact discovered within the section as equivalent to the object produced. The fact discovered embraces the place from which the object is produced and the knowledge of the accused as to this, and the information given must relate distinctly to this fact. Information as to past user or the past history of the object produced is not related to its discovery in the setting in which it is discovered. Information supplied by a person in custody that I will produce a knife concealed in the roof of my house does not lead to the discovery of a knife. Knives were discovered many years ago. It leads to the discovery of the fact that a knife is concealed in the house of the informant to his knowledge, and if the knife is proved to have been used in the commission of the offence, the fact discovered is very relevant. But if to the statement the words be added with which I stabbed A, these words are inadmissible since they do not relate to the discovery of the knife in the house of the informant. It could thus be seen that Section 27 of the Evidence Act requires that the fact discovered embraces the place from which the object is produced and the knowledge of the accused as to this, and the information given must relate distinctly to the said fact. The information as to past user or the past history of the object produced is not related to its discovery. The said view has been consistently followed by this court in a catena of cases. This court, in the case of Chandran versus the state of Tamil Nadu, had an occasion to consider the evidence of recovery of incriminating articles in the absence of record of the statement of accused number 1. In the said case also, no statement of accused number 1 was recorded under section 27 of the Evidence Act leading to the recovery of jewels. The court found that the sessions judge as well as the High Court had erred in holding that the jewels were recovered at the instance of accused number 1 therein in pursuance to the confessional statement exhibit P27 recorded before PW34 therein. Stop.